Both voting and jury duty are core civic responsibilities. But while voting is optional, jury duty is not. Once called, you've got to show up to serve. Recently, more jurors have come forward to describe the emotional aftermath of serving, especially on trials with gruesome details. It's become a real question as to whether that duty has become an unfair burden. Joining us now to look at the civic importance of jurors and whether they're receiving the supports they need, here's Chris Spire. He's a former Ontario Superior Court judge, Indra Stewart, Toronto-based criminal lawyer, and Vanessa McDonnell, professor in the Faculty of Law at the University of Ottawa. And it's good to have all of you around our table here tonight for this important conversation. We just heard from Mark Farrant, a former juror who has been suffering from PTSD ever since he had to deal with the extremely gruesome elements of his case. Do you think, former judge, let's start here, do you think jury duty has become, in some respects, an unfair burden on citizens?
On balance, I'd say no. I think that it has always been an inconvenience, but when it rises to the status of an undue hardship, then I think we have to take a look at the system. I do know of certain cases where it has been a burden. I'm not sure how much we can do about it.
You've sat in cases where you could tell it was a burden?
In one particular case.
What was the case?
It was a murder case I did in Brampton.
In Brampton? And you could tell the jury was...
No, I knew about it as a result of going back and speaking to the jury, not about their verdict. I brought a court constable with me. But there were two women in particular who had dissolved themselves in tears and were really emotionally distraught by the experience.
Were there supports for them?
No, there weren't. When we get into this, a lot of times the judge just doesn't know. When trauma occurs, it occurs likely either weeks, months, or days after the trial is over. We just don't know about it.
Gotcha. Professor McDonnell, you surprised to hear about stories like this?
No, I think there's no question that over time, trials have become a lot more complicated. They run longer. The types of evidence that juries hear today can go on at some length. They can be quite gruesome. And so I think there's no question that for jurors, this can take a toll. And that the supports that we provide to jurors really haven't kept pace with some of the developments that we've seen in terms of the complexity of jury trials and the types of evidence they hear.
Indra Stewart, what's your sense about how well jurors are supported to do their civic responsibility?
I think, well, we know that jurors, I think we'll talk about it later, but judges have historically had the opportunity to order counseling for jurors, but that's something that doesn't routinely happen.
They can order it, though.
If
they see it's a problem, they can order it.
Yes, but because of the secrecy provisions surrounding jury deliberations, judges often don't know, as Justice Spire has said, the burden it's been. I think one thing that's also important to note is, the criminal evidence itself can be very disturbing, but the whole sort of environment of a serious criminal trial, it's a new experience for jurors. It's a foreign experience. They're told they're not allowed to go home and talk to their loved ones about what's going on. And it's a very somber experience. You often have the loved ones of the accused, the loved ones of the victim. They're there every day. They're emotional. The witnesses are often emotional. So there's a lot of emotional complexity to a trial beyond sort of disturbing photographs or disturbing evidence.
The whole thing is pretty intense, isn't it? Or can be, anyway.
Very, very intense. And then, as I said, they're not allowed to talk to anybody about it.
I want to follow up with Judge Spire on that. Should we change that practice of jurors not being allowed to ever talk to anybody else about this while the trial is on, to sort of give them that safety valve, if you like, to blow some steam off or whatever?
It seems natural to do it, but there's dangers that are attendant to it.
Such as?
If I went home and I told my wife about what I had heard, it would be likely that my family in some way might taint my opinion as to what I would do. And I always have told juries, and every judge tells juries, do not speak to anybody for fear that they will influence you and you won't just focus solely on the evidence, which is your sworn duty.
The impact of that, however, is that you take all of that gruesomeness, potentially, of the trial into yourself, and you have kind of no way to deal with all of that stress and intensity and so on. So what do we do with that?
But Steve, this has happened since time immemorial. I mean, this isn't something new. Murder trials in particular have always been gruesome events. There are some things that are occurring presently in murder trials, such as videos that we didn't see formerly. But it's always been a difficult and challenging lot to be a juror. And so this, I just want to remind you, this isn't something new. And the real problem is this: what can we do for jurors who suffer post-trial? And how do we find out about it? Most people wouldn't want to even talk about it.
And I think, Steve, every person is going to react differently, the same way that every criminal lawyer, every Crown reacts differently to the evidence in the case. I have colleagues who say, after I had children, I'm not able to do child pornography cases anymore. It's just too disturbing. I can't look at the evidence. Other people don't have that reaction. So every person is going to react differently.
How often do you hear of cases where people, once you're called, you got to show up, but they will do, whatever they have to in order not to be selected?
So juror absenteeism is a problem that we deal with in the system. And so sometimes you have the problem of jurors just not showing up, but oftentimes what also happens is that jurors seek to be excused from jury duty. So this is where a potential juror acknowledges a jury summons, but then provides some reason for not being able to attend. And,
like what?
And well, there are a whole host of reasons, but unsurprisingly, particularly in long and complex trials, it really asks a lot of people to step away from their lives and sit in a trial that could last for weeks or even months. And so if we think about childcare responsibilities, elder care responsibilities, if you're a small business person who simply can't afford to take the time away from work, those can all be legitimate reasons to seek to be excused from jury duty.
What else do you hear?
Health issues is a big one. So people who say, I have a back issue, I can't sit like that for hours upon end. Now, judges are sometimes able to address that by giving extra breaks, that sort of thing. I think, as Vanessa said, childcare is a huge one.
Is that legit?
Childcare?
No, I'm saying if somebody were to come forward and say, I'm sorry, I can't do this trial because I have childcare responsibilities, would a judge be more or less likely to inclined to agree to that?
I think more likely. I think from what I've heard, the thing that people say that's not very compelling is when someone comes in and says, I'm a big, important business person and my company couldn't possibly manage without me. And I've heard several judges say, too bad, figure it out. Someone's got to cover it. But I think someone who comes in and says, I'm unemployed and I'm looking for work and I can't afford a month off from that search process. Or
does that work?
I mean, it's so judge specific,
okay.
But I think that is, can be a very compelling reason. And just quickly, I think from what I understand, in Quebec, they do give a stipend for childcare, and it's based on the number of dependents you have. And so I think if we want to have a more diverse jury, we need to think about things like that, covering things like childcare.
Can you let us into your thinking a little bit on this? What were you inclined to give people a pass on? What were you not inclined to give people a pass on?
Well, a couple of things. I don't know of any judge who wouldn't allow a person either to defer jury duty or be discharged from a particular jury if, for example, they were going to lose a lot of money. Say, for example, you're a single businessman. Your business is going to come to a halt. It's only you. Well, that's an exceptional hardship, and I'd be very surprised if a person wasn't discharged because of that. If you're a single mom and you have to take care of a child, that's another thing. One of the other things that you have to take into account is this, that most judges and lawyers want jurors who want to serve, okay? And you don't want on your jury somebody who's going to act irresponsibly and who's going to be discontented with, sitting on a jury. And that all goes into things. I like Indira's point that there are some people who have senior positions in important companies and think because of that, they should be exempt from jury duty. Well, that'll get nowhere. It certainly didn't with me.
What? Give me an example.
Well, I wouldn't like to give a specific example.
You don't have to name names, but somebody came forward and said...
Somebody from a bank said, you know, I'm this, and we've got these things going on in the next 2 or 3 weeks. I'd listen very carefully to what it was. I might discharge them from that jury, but I would only give them a deferment. I wouldn't allow them to, you know, get out of jury duty.
What's the wackiest excuse you ever heard given for why they shouldn't be forced to serve?
I won't say the wackiest, but one of the most disturbing is, I just don't want to do it.
Huh. And did that have any sway with you?
It wouldn't, but it sure would with the lawyers who were listening to that. And no lawyer worth his salt or her salt is ever going to say, I'm content with a juror who doesn't really want to be there.
Well, that leads to my next area of inquiry, which is, we've seen this in the States. I don't know how much of this is happening in Canada, and you can tell us, Indra, about that. There are consultants who make a pot full of money in the United States judging whether or not they believe jurors are good for their clients, obviously. Do we do that here?
We do, in my experience, very little of that. And I think there are a few things. So one, because of, again, the secrecy provisions surrounding jury deliberations, we don't have social science data in Canada about what jurors are thinking, what's influencing their decisions. So any research we have on that would come from American studies. So that's one thing. But, you know, the reality is that I haven't really seen that at all. There are little tips that criminal lawyers pass back and forth. You know, I think it's a well-known secret that criminal lawyers love teachers, for instance, and crowns typically challenge teachers.
Why?
But, I think that because they seem to be compassionate and may have compassion for the accused. But in terms of the as I said, we don't have the social science data, and I think it's a real issue. If that idea of these jury consultants was to come to Canada, is that something that legal aid would pay for? Is that going to be something that's even accessible for a client of modest means? I doubt that legal aid would pay for that, honestly.
When you are considering whether or not you want a juror on your trial, because it's either in or not in the interest of your client, how much do you actually know about the jurors?
So you have jury lists that have the juror's name, you have their address, and you have their occupation. Now, occupation often says retired, so we have no idea what they did before. It could say something like sales or something very generic. Really, it's a gut reaction because you know so little about them. Now, there are some questions that you can ask jurors, and there's a process for doing that, but it's a challenge for cause. So having the opportunity to ask jurors about whether they've seen media about the case and they've been influenced by that media. We also have what's called a Parks challenge. So that's an opportunity to ask a juror whether the fact that the accused is a black person or an Aboriginal person or a person of a different race would impact their ability to be impartial. So we do have those provisions, but very few people get up in front of a group of their peers and say, I can't be impartial.
Having said that, I mean, I think you probably, I shouldn't say no, but you can probably surmise a lot of people. You know what gender they are, you know what race they are, you know what age they are. I mean, all of that presumably gets considered in the mix as well, doesn't it?
I think as a practical matter, it does get considered. Where some of this can become concerning, of course, is that all of these assumptions are really based on stereotypes.
Yes.
And one of the things that we've seen is that oftentimes jurors end up being dismissed or challenged. There's also, in addition to these challenges for cause, there's also something called a peremptory challenge, which allows the Crown and the defense to challenge a certain number of jurors without providing any reason for challenging. Right. And we know that those challenges can be exercised in a discriminatory way, again, based on stereotypes about certain groups or individuals being more or less likely to sympathize with the accused. So certainly that is a concern, that these the types of assumptions that can be made based on very limited information. That's not necessarily an argument, though, for opening things up to a U.S.-style jury selection process where you start asking a lot of questions of jurors. I think that I mean that would represent a fairly fundamental change to our system.
Let's just introduce into our courtroom here, shall we, some evidence about what it's like to be a juror in the province of Ontario today. For example, Sheldon, let's bring this graphic up. In Ontario, jurors are paid nothing for the first 10 days of a trial. On the 11th day, they are paid $40 a day. and that will increase to $100 a day, but only if the trial goes more than 50 days. There are exceptions to this, and for example, jurors in the Tory Stafford trial were paid $40 a day from the beginning. Let's start there. Judge Spire, do you think jurors need to be better compensated?
If it was up to me, the answer would be yes. I'm not as concerned about short trials. And as I was saying to Vanessa and Indira before we came in here, I was talking to a friend of mine who was a celebrated Crown attorney and a very eminent judge. He did 30 some odd murder cases, and not one of them lasted more than a week. I would say that in those type of cases, you're doing your civic duty. Where it becomes problematic is if you are on a long trial, 3 months, 4 months, half a year, things like that. Then I think that somebody should take a look at the issue of compensation.
Are employers required to pay the salaries of employees who are called to jury duty?
No, they're not. So the Juries Act says that you're not allowed to fire someone for serving on a jury, but that you don't have to pay them either. And so I am concerned about this, even in short trials. I think this provides a reason for many people to say, I just can't do this, right? The first 10 days, you're not paid anything. Even some of these longer trials, this is not a meaningful income supplement. And so if we are interested in having juries that represent the diversity of our society, we have to think about the impact of asking people to forego income for 10 days or to get by on a very modest stipend.
Let me flip over to the other side of the coin. Let's say you are prepared to do your civic duty, you're prepared to do jury duty, but you're going to have to spend, I don't know, $100 a day or $50 a day hiring a babysitter to take care of your kids or pick them up from school. Would that be covered?
Well, so again, this is currently, we don't provide these kinds of supports, but in 2011, there was actually an important study that came out. Former Supreme Court of Canada Justice Frank Iacobucci reported on representation on First Nations juries in Ontario, and he identified some serious deficiencies in terms of Indigenous representation on juries in the province.
Hold that thought. I got this right here. We got a graphic on this. Katie O'Connor, our producer, thinks of everything here. Should we bring this up? Here's Frank Iacobucci, who did this study on how First Nations people are represented on juries, and here's what he found. The report highlighted that in the Judicial District of Kenora, Northwest Ontario, makes up a third of the province's landmass. 30 to 36% of the population live on reserve. These people only make up 10% of the Kenora jury roll. In the Thunder Bay District, people living on a reserve make up to 5% of the population, but only account for 1.3% of the jury roll. All right, what does that tell us?
So what this tells us is that there are serious representation problems when it comes to Indigenous people on juries. And one of Justice Iacobucci's recommendations was actually that we look at expanding the supports that we provide in terms of childcare, elder care, to free people up so that they can serve on juries. But certainly in Northern Ontario, there are some very serious deficiencies in terms of the extent to which Indigenous people are getting onto jury rolls and then ultimately onto juries.
Can you, Judge Spire, just help us understand what the consequences are of a jury pool that is not representative of the greater population?
Well, my experience has been in the Toronto area and in the area of Brampton, Milton, and Halton. And so I think that it is fairly representative. I don't have the experience in Northern Ontario that Justice Iacobucci was talking about. It is a problem, I agree, but I only know it anecdotally.
It's a problem because why?
Because you would like to have a representative population on your juries. It's as simple as that.
Because what would that give you that you'd be concerned
that
if
people
it weren't
are
there?
included. The feeling, the civic feeling that everybody is included.
Does it have an impact on a defendant's right to a fair trial if, you know, the makeup of the jury is not representative of the population as a whole?
I think certainly. I mean, we can't have a perfectly representative jury, but I think that, you know, the whole idea of a jury of one's peers, right, means that you have people, you have 12 people bringing their unique perspectives. They come from different socioeconomic backgrounds, different racial backgrounds, different religious backgrounds, and they all come together and they go into that room in secret and they look at the evidence and they hopefully come out with a fair result. And I think that, you know, if we have people who are all the same, it really impacts that procedure. But I would say, Steve, and I think Justice Beyer would agree with me, that the jurors they usually get it right, even in our current system. You know, it may not be perfect, it may not be diverse enough. There are all these challenges. But I think that by and large, not all the time, but by and large, jurors, they take their job really seriously. They show up on time. They often come wearing suits, people who wouldn't necessarily wear a suit to work, but you see them, they're in suits, they're taking notes.
Shows how seriously they take the process.
They take it so seriously, and they usually get it right.
You know, my ears prick up when I hear the word usually, because that, of course, means they don't always get it right. And if I'm the defendant, and I'm one of the times when they don't get it right, that's problematic, isn't it?
Sure, but you know, no offense meant to Justice Beyer, but judges don't always get it right either.
Right. Or journalists, I hear. That's another story.
Can I just intervene
Please.
on that? I think Indira has hit a key point, and that is how good juries are. And you know, it's been my experience, at least, that almost inevitably, I think verdicts are justifiable. There are some miscarriages of justice, and we have to address those. But nevertheless, the jury system has really served us well. It's the bulwark of our democracy.
I would just intervene here to say that one dynamic that we really need to pay attention to when we're talking about Indigenous representation on juries in particular is not only do we have Indigenous people underrepresented on juries, but they're overrepresented dramatically as accused people. And so there is an important dynamic here where when juries are not representative, there's a sense very much that the group of people doing the judging and the group of people being criminalized are not the same groups. And so I have a lot of respect for the institution of the jury, but I'm very concerned about these representativeness issues that have been identified. And I think we find often, not just in the context of Indigenous people, but the people who are sometimes excluded from juries are people who are marginalized. They're the people who can't forego 10 days income. They're people that maybe the Crown perceives is more likely to be friendly to a racialized accused. So there is a dynamic here that I think we have to be attentive to.
Judge Spire, in our remaining moments here, let me throw another angle on the table, and that is, you know, we know in the United States when they finish a trial, jurors often get book deals. You know, if it's a really big trial and lots of headlines, they're talking about it ad nauseum. What's the practice here in Canada about how much you can or should talk about your experience in the jury box once the trial's over?
Well, there's nothing wrong with talking about an experience. If you discuss the case, how you arrived at your verdict, anything about the evidence, that's prohibited by the criminal code, and you always caution a jury that it's confidential. Indeed, it wasn't like that. When I started practicing law, I would always talk to juries afterwards, you know, find out how they came to their decision. But then Parliament, in its wisdom, and I think the Parliament was quite right, Parliament said, look, these verdicts are confidential. How you arrive at the verdict is confidential. We don't want people besieging jurors afterwards and questioning how they got there.
What do you hear from jurors today? I mean, I presume now you're at liberty to talk to anybody about any of this kind of stuff. What do you anecdotally hear from them about the experience of doing that job?
I'm glad you asked me that, because I always spoke to juries after a case.
When you were a judge?
Well, yes, when I was a judge, but I would always bring a constable in with me, and I would remind them of what I had told them in court, that they couldn't discuss the evidence or anything like that. But I would ask them questions. How did you enjoy the experience? I would ask them, how can we do it better?
Did you get good feedback on that?
I did. I got a lot of good feedback, and I would pass it on. Can
you give us one idea about how they'd improve things?
In one particular case, we've mentioned what a Parks challenge is, and that is racial bias. There was a black juror who once said to me after a case that he was hoping that there would be more questions asked with respect to that, not just the Parks question, but follow-up questions. But the thing I really take away from it is, after it's all over, what a rewarding experience it was for jurors. Almost inevitably, after they had served, it was a very rewarding experience.
Indra, if you could make one change to improve the jurors' experience, what might it be?
I think it would probably be compensation. I think that's the number one thing that bars a lot of people from serving. I think people say, I'm willing to do it, but I don't want to do it at a cost. But Steve, the one thing I really wanted to get through, if I could, was that so many people call me and probably call both of these people and say, how can I get out of jury duty?
How can I get out of it?
Get out of it. It's the number one question I get. But it's such an important civic duty. I really can't stress that enough from the perspective of my clients, people accused of crimes. It's crucial having the exact kind of people who watch TVO, smart, informed, thoughtful, fair people serving on juries. So I implore people not to sort of, to take that seriously and to not try to get out of it.
In which case, Vanessa, in our last minute here, give those very smart, educated, et cetera, viewers out there one idea about how you would change the mentality around having to do jury duty.
Well, I think I would just build on what Indra said, that this is, at least in the way our system is currently structured, a very important function of in our democracy, and that we owe it to accused persons to give them a fair trial, and that means that we need jurors who are going to approach the evidence with an open mind and fairly. And I would also say we sort of in return owe jurors some obligation too. And so I think the province and the federal government needs to look at what support services we can provide so that jurors are really freed up to do the best possible job they can do, and to ensure that all Ontarians feel that jury duty is something that's manageable for them. And so I guess that's where I would leave it.
Terrific. That's Vanessa McDonnell, law professor, University of Ottawa; Indra Stewart, Toronto-based criminal lawyer; Chris Spire, former Ontario Superior Court Justice. Really great having all three of you here tonight for this most important discussion. Thanks so much.
Thank you, Steve.
Help TVO create a better world through the power of learning. Visit TVO.org and make a tax-deductible donation today.